Hi there, I'm Keith Cassabon, the host of You First, the Disability Rights Florida podcast. We'll be back with new episodes next month, but in the meantime, we've been releasing encore presentations of some early episodes that still ring true today. This month, we bring you our 14th episode, Accessibility in Florida Prisons. This episode was originally released on November 21st, 2017, when Disability Rights Florida was suing the Florida Department of Corrections over an enforcement of a settlement agreement signed the summer of that year. That settlement agreement was intended to ensure that individuals with disabilities in prisons were having their rights vindicated under the Americans with Disabilities Act. But over the years, we learned that many of these provisions were not being enforced, which led to the lawsuit. Since that time, the two parties have settled with stronger language and oversight, but the struggle for the rights of individuals with disabilities in prisons continues. The prison population not only has a larger population of individuals with disabilities than the general population, but in Florida especially, it is rapidly aging, making the ADA in prisons more important than ever in this state. As we continue our work in this area, please enjoy this encore episode of You First and see the show notes for links to more information.
Welcome to You First, the Disability Rights Florida podcast.
Hello and welcome to You First. I'm Keith Cassabon and thank you so much for listening. As I'm sure many of our listeners know, the Americans with Disabilities Act of 1990 ensures that people with disabilities are not discriminated against because of their disability. It assures us that employment opportunities exist, that public buildings are accessible, that transportation is made available, and much more. Well, the ADA also includes prisons. In Florida, prisoners with disabilities were not receiving the same access to programs or services that other prisoners were receiving. So to tell us more about what Disability Rights Florida did to remedy those oversights, we have David Boyer, Director of Investigations at Disability Rights Florida, and Molly Paris, Assistant Director at Florida Lawyers Assistance, and formerly a member of our investigations team here at Disability Rights Florida. Thank you both, Dave and Molly, for joining us today.
Thank you.
Thank you for having us.
So please just start us off today with a brief overview of what this case, officially known as Disability Rights Florida versus Jones, is all about.
Okay. Well, this case started back for many years, Disability Rights Florida has been receiving letters from inmates directly and from family members of inmates in the Florida prison system. And just to note, before I delve into the case, this has to do with state prisons. This is not, every county has a jail, but this does not. This case is strictly the Florida state prisons. So we were receiving quite a few letters from inmates about the violations that were going on in these prisons throughout the state of Florida. And they were from folks with a variety of disabilities, too. Folks that were blind and had visual impairments, deaf and hard of hearing, and then also mobility impairments. And for quite a few years, we were receiving these letters. And in 2013, we sort of joined forces with another agency called the Florida Justice Institute, and they have been doing prison cases for a number of years and really have a lot of expertise in that area. And we talked with them about the case, and we decided to co-counsel and tackle, because we could not address all of these individual letters that came, all of these individual complaints. There's certainly, there were probably hundreds per week. We had to really tackle it on a larger scale. So that's how the case came about. And that's how we got started. So that's when we started our investigation. Back in 2013 is when we first met with the Florida Justice Institute and decided to file this lawsuit.
So how did you guys prepare the case?
We actually spent a couple of years preparing the case. Because this was such a large-scale case, it's not something that could happen overnight. We spent a couple of years gathering our evidence. And the way that we did that, first of all, I already mentioned the letters. We sort of divided those up and looked at the different types of violations that were happening. I'll give just a brief example from each disability group. For example, with our deaf and hard of hearing folks, the prisons were not providing interpreters for very important services, for example, medical appointments, disciplinary hearings. Also, there were sort of archaic TTY telephones. Folks were not able to communicate with their families the same way that inmates without disabilities were able to.
It sounds like they couldn't even communicate with the other people in the prison, and like you said, the doctors.
Exactly. And the lack of interpreters, like I said, it was medical appointments, psychiatric appointments, disciplinary hearings, work. They were really being excluded from work opportunities as well. Some of the prisons have a program. For example, the one that is very common in the Florida prisons is a program called Pride, and that gives inmates an opportunity to work and really as part of their rehabilitation process, some of the individuals that are going to be getting released and some of the work opportunities were simply not available, and they were being just outright excluded. The blind and visually impaired inmates, there were a variety of issues there. The first was just the physical access, getting around the camp. The inmates will, refer to it as a camp. They have something called an impaired inmate assistant, and that is another inmate is assigned to an inmate with a disability to perhaps, guide them throughout the camp or help them with reading, help them in classes, things like that. And we were getting a lot of complaints that these impaired inmate assistants either they didn't have one, so they were left on their own to try to navigate the compound with no help, or there were impaired inmate assistants that were exploiting them and saying, I'll only help you get to the dining hall if you give me money or if you give me your food from the commissary.
Oh, wow.
And there were also, we had inmates that were run into the wall. I had one gentleman who was named in our lawsuit that was run into the wall numerous times by his aide. I don't know if it was on purpose or just that he was negligent, but he kept getting hurt. And the folks with mobility impairments, there were a variety of issues. Some of them had to do with the impaired inmate assistants. The folks were not pushing them, or they would have a wheelchair pusher who got in trouble and got sent to confinement, and then the individual with the disability would be without it. And again, a lot of the exploitation. And then we also had an issue with folks that had prosthetics. They were being taken away for security reasons, a prosthetic arm, a prosthetic leg. There was one inmate who was an amputee, and he was put on a second bunk, on a top bunk.
Oh, my gosh.
Yeah. So we learned about these issues, and then we sort of hit the road. And we looked at, I don't have the exact number in front of me, but Florida has more prisons than most states. And Florida is also a very large state. So we split them up. At this point, it was David Boyer, myself, and a couple of the attorneys from the Florida Justice Institute. And then we also included a woman named Sharon Caserta, who has a lot of expertise in deaf and hard of hearing issues. She's actually a sign language interpreter in addition to a lawyer. She also co-counseled the case with us. She was originally at Jacksonville Area Legal Aid, and then she moved to Morgan & Morgan. So this legal team that we put together sort of split up the state, and we traveled to prisons all over the state with interpreters where appropriate when we were going to visit with deaf inmates. And we interviewed a lot of people. That's how we got a lot of our information. And again, we investigated this for several years. So we looked at the letters, we found out what the issues were, we interviewed folks. We found the ones that had really compelling stories, we looked at their records. So they authorized us to request their records from the Department of Corrections, and we looked at thousands of records, grievances, disciplinary reports, medical records, responses to the grievances, requests for accommodations and modifications. We looked at numerous records.
Wow. It sounds like it was quite a laborious process. Was this a class action, essentially?
Well, that's an interesting question. The traditional way to bring one of these cases is to, you get a client who has, a visual disability or is deaf or mobility impaired, and then you sue the Department of Corrections. That's the traditional way. Or in a traditional class action, what you would do is find examples of each of these disabilities and then sue based on that group of individuals, that class action lawsuit. In this case, we filed our lawsuit based on our standing, or our ability to sue as Disability Rights Florida as an organization, based on the fact that we have clients and constituents with disabilities, and we are federally mandated to bring lawsuits based on those clients and constituents. And that's how this lawsuit was organized. So we were actually suing them as an organizational plaintiff, Disability Rights Florida versus the state of Florida. That provides some good benefits in a lawsuit. Number one, it sends a message that Protection and Advocacy Agency for the state of Florida is behind this. We've put our name on this.
Right.
We stand behind this. Unfortunately, prisoners may not have the best reputation to bring a lawsuit like this. That class of folks has their own stigma attached to them, and the fact that we, as an organization, stand behind this lawsuit, is a little more effective sometimes. Additionally, the law governing lawsuits like this, the Prison Litigation Reform Act, which was brought into being a few years ago, really limits the ability for prison inmates to file lawsuits like this. They have to go through a long series of administrative remedies. They have to file several grievances.
Really? Wow.
Yeah, so those grievances actually have to ultimately be filed with the Secretary of Corrections for the state of Florida. So you have several levels, 3 or 4 levels of grievances that have to be filed, and those have to be all filed before a prisoner can bring a lawsuit. So, in a case like this, if this were a class action, a traditional class action with 100 inmates, then you would have 100 inmates trying to file 3 or 4 grievances per inmate.
It sounds like an organizational nightmare.
Right.
Yeah.
Right.
Okay, so the case is filed. What happened in the case?
We filed it in the Northern District of Florida in federal court, and as I said, the pleadings are all available. I believe that you can get them. I think the complaint. There's a link to it on our website. And
I want to add at this point how complex this complaint is. A typical federal complaint is maybe 20 pages long. Mm-hmm. Molly, how long was
It was 123 pages.
Wow.
It was a 123-page complaint. So very complex, very detailed in that process.
Exactly, and it was certainly the longest complaint that I had ever worked on. So the complaint was filed. Judge Hinkle was our judge in Tallahassee, and from there, just sort of the usual procedures of a federal lawsuit started, and the state filed their response, and then the process of discovery started. And discovery is just, when each side has an opportunity to glean more information from the other. And at that juncture, we requested a lot of documents. We had well over to get additional information. We had the information that we used to file the complaint, and then we needed more information to really continue to work on our case. So we requested more inmate records, also, logs of wheelchair use, site plans, accessibility, architectural issues. And we requested, it was well over 100,000 pages of documents in discovery, and we reviewed all of it. That was over a period of a couple of months. The Department of Corrections, in turn, they requested documents from us. We provided them, and we have an electronic discovery database. So this all took place electronically, not like in the old days when you were sending each other paper.
With that amount of pages, that would have been quite cumbersome.
Yeah, it's like entire rooms filled with documents.
Wow.
exchange of information took quite some time. And also part of our discovery in getting more information and building our case, we hired experts. That's something, we like to think that we're experts in disability law, but we're really not experts in some of these more specific issues. And we really need folks that are published and have been doing this for years and really know what they're talking about. So we hired 3 different experts, one for each area of disability. And we hit the road again. We interviewed hundreds of inmates. With the architect, he took these very detailed surveys of each facility that we went to. The Department of Corrections had folks there. We had our folks there, and one attorney was able to accompany the expert. And each of the experts wrote a report, and that became part of our case. While this is happening, the defendants, the Department of Corrections, started to take depositions of some of our folks. More documents are being exchanged, and we are gathering a lot of this information. And then, as is par for the course in many federal lawsuits, many lawsuits in general, we filed something called a motion for summary judgment. I won't get into all the specifics of what an MSJ is, but it had all of our expert reports, and it's a way to say, here, judge, this is our case, rule in our favor. Look at the facts and look at the evidence. However, right around the same time that was happening, we were instructed to go through mediation. And that started in the beginning of 2017, was our first mediation session in January of 2017. So
And that lasted 42 years, I think. No, maybe not.
Probably felt that way.
It lasted until July when the case was finally settled. So do you want to talk a little bit about the mediation?
So the mediation was in 6 or 7 sessions. Typically, your mediation in a federal case is you go to mediation one day, and maybe 2 days, and either reach an agreement or not, and then go to court. But in this case, it was really a process of our attorneys meeting with the Department of Corrections attorneys, both with our expert reports and both with the impressions of our experts. And for 7 or 8 times we met, worked out all of the little details of how this lawsuit was going to be resolved. What types of things were the Department of Corrections going to do to change their system or change their facilities, change their rules in order to accommodate our folks with disabilities. It was very detailed, down to every line. It just I can't stress how detailed it was. For someone who's, a little more global thinker like myself, it was very tedious. And for 7 or 8 sessions, we worked it out, and we came up with a settlement agreement that completely resolved all of the issues in the lawsuit.
Oh, wow. So the end result was a settlement agreement. I imagine it itself must have been very detailed based on everything else you're telling us. So can you describe that a little bit?
Sure. I have to say that the Department of Correction, it was an arduous process, but we really did iron out all of the details and all of the issues in the case. And, we conceded on some issues, they conceded on some issues, but ultimately the settlement agreement was a really sort of a work of art, if you will, and it really provided a lot of remedies and protection for our individuals, the folks that the exemplars in our case and the inmates. And so some of the examples of the things that the settlement included, they're going to be hiring more interpreters. They're going to have on-site interpreters, video phones. And Florida is one of I think there are about 7 states now in the whole country that have video phones in their prisons. Department of Corrections agreed to install video phones. That was a tremendous victory for us and for our folks.
Wow.
And in terms of the blind and visually impaired folks, they're going to repave the tracks so it's easier for people to walk. And if they use a white cane, install talking software in the library, in the law library, so people that are blind will have access to their cases, to be able to file their appeals, to be able to defend their cases. And then also Mark Maz, our architectural expert, worked with their building person at the Department of Corrections and just went through really, bathroom by bathroom, prison by prison, and the Department of Corrections agreed to make a lot of changes. Some of them short term, some of them could be fixed right away. Some of them just meant, installing a grab bar or moving something to a different area. And then others involved some pretty serious construction, knocking down walls. And the department really met us there with the architectural issues. So it included that. And then some more global issues, access to some of the issues, people being able to go to Pride. That was the work program that I mentioned earlier in our talk, that people were not going to be excluded on a systemic basis from Pride just because they have a disability. Repairs, repairing white canes, repairing wheelchairs, repairing telephones, the video phones, the TTY phones, replacing prosthetic devices that don't work. Those are sort of some of timelines were put in place with respect to how long, so people wouldn't languish. If there's an impaired inmate assistant that's missing, there'll be the department agreed to have sort of a pool of impaired inmate assistants so that if one gets sick or one goes to confinement, the individual with a disability is not going to be left without someone to push them to the dining hall, and they'll have to go for days and days without eating. So these were, again, the settlement is also, that's public record. And it's again, we feel like it's a work of art because it took a lot of time and it really is going to reach hundreds, thousands of people. Really, it will.
Sounds like years in the making there, too.
Yes. So that's sort of the crux of it's hard to think of without going through it bit by bit, but those are some of the big...
Right. In addition, we have 4 years now for the Department of Corrections to implement all of these changes. Some of the changes, like Molly said, are going to be immediate, and they're pretty small, but some of these changes are going to be program changes or construction changes or, rule changes that have to go through a whole process of administrative review. So for about 4 years now, we will be monitoring this lawsuit. We'll be, as Molly says, hitting the road again and, touring these facilities to make sure that the changes are implemented. We'll be working with Department of Corrections and with our partners at the Florida Justice Institute and Morgan to make sure that this settlement agreement, isn't just a piece of paper, that it actually has some teeth and actually results in these changes.
Sounds like the settlement is really just the beginning.
Yes. Yeah, I think you're right. You figure out what's to be done. Now we have to actually make sure that the Department of Corrections does what they say they're going to do. And
the inmates themselves, are they aware of the settlement or how do they know about it?
They do know about it. There's communication within the prison system that happens both informally and formally. The inmates are pretty good at communication amongst themselves, and they've gotten the word out. In addition, we've mailed letters to all of our, the inmates that we've collected information on. So we mailed out a series, both us and Florida Justice Institute and Morgan all mailed a series of letters to the inmates notifying that a settlement agreement had been reached. And now the Department of Corrections has placed the settlement agreement in each of the law libraries in the facilities. So inmates are able to go down and check that out.
Well, this really sounds like quite a massive and successful undertaking that we've gone through here, and very excited for this. And I can't wait to see how the monitoring continues to play out. All right. Well, Molly and Dave, thank you so much today for talking to us about all this. Again, it sounds like quite an achievement, and so much was done to make this happen. So thanks again for talking to us and all the work you guys did on this.
All right. Thank you. Yes, we're very happy about about it too. It was quite an endeavor, but it's, as I said before, it's going to reach thousands of people with disabilities, and that's Disability Rights Florida's mission. This was a really big achievement for us, and I think a lot of our folks really felt like they were vindicated.
I agree. Thanks, Keith. Thanks for taking the time for this.
Excellent. And thank you to everyone for listening to the You First podcast or reading the transcript online. Please email any feedback about the show to podcast@disabilityrightsflorida.org.
The You First podcast is produced by Disability Rights Florida, a not-for-profit corporation working to protect and advance the rights of Floridians with disabilities through advocacy and education. If you or a family member has a disability and feel that your rights have been violated in any way, please contact Disability Rights Florida. You can learn more about the services we provide, explore a vast array of resources on a variety of disability-related topics, and complete an online intake on our website at disabilityrightsflorida.org. You can also call us at 1-800-342-0823. Thank you for listening to You First, the Disability Rights Florida podcast.